So what is this power? When the legislative assembly is not in session, he must be satisfied that such circumstances exist which render it necessary for him to take immediate action. The ordinance making power of governor is coextensive with the legislative power of the state legislature. Both can be treated as laws, are treated as laws. Governor can also promulgate the ordinances to amend or to repeal not only other ordinances, but also by any law passed by state legislature, subject to limitation prescribed in 2131A, and even allow the ordinance to operate retrospectively. This is important. He is the sole judge as to the existence of the circumstances necessitating the making of an ordinance. It is well settled that necessity of immediate action and of promulgating the ordinances is a matter purely of subjective satisfaction of the governor. Subjective satisfaction of the governor means his personal satisfaction about the existence of necessity in the given circumstances. Now, friends, issue of ordinance is based on the advice of the Council of Ministers. But about its urgency, whether it is immediately required or not, it is his personal satisfaction. He is the sole judge, right? Now, this is an important case. We have already discussed about repromulgation of the ordinance, right? 256 times. Yeah? Yes, if you remember. So, what are his judicial powers? Judicial powers means when he can act like a judge. That is the power to grant pardons. Right. Okay. So, we were talking about the judicial power of the governor. As we know, like President has the power to grant pardon. Similar power is with him, but cannot pardon for the cases where his punishment is by the court martial or for the death sentence. If you see the comparison with the president, that covered, well, I can't say how much you missed, but you can immediately after the class is over, it is uploaded. You can, today itself, you can go through the portion which has been, now onwards at least, it should not have happened. So in respect of suspension, remit or commute death sentence, both president and governors have concurrent powers. Only difference lies is with respect to pardon of death sentence or court martial. But if it is to be reduced to a lower sentence, then they have or suspension or remission of sentence, then both have concurrent powers. The governor of a state shall have the power to grant pardon, reprise, respite, or remission, which the executive power of the state extends. You know, there is a controversy on this. Can you remember that controversy? It is still going on. About the pardoning power of the governor and president with respect to assassins of Rajiv Gandhi. They are all undergoing, particularly, what's her name, that lady's name? Do you remember her name? No, I don't remember. Yeah. She gave birth to a child in the prison itself. Yeah, Rajiv Gandhi case. they were all undergoing life imprisonment. So there is a great demand from certain quarters that they should be Nalini. Yes, you gave the name. Right, thank you. So they say that, she should be pardoned, right? But that pardoning power, there is a dispute as to who has, particularly with respect to the offences where the executive power of the state extends. So whether those offences come under this or not, that is the question. You can even go through it as a case study. I'll also try to get some material. So one of these days we can discuss that also. So, exercise of pardoning only on the advice of respective government. Now, can be exercised by central and state governments and not by president governor on their own. The advice of appropriate government binds the head of the state. There cannot be any dispute with proposition of law that power of granting pardon under Article 161 is very wide and does not contain any limitation as to the time on which and the occasion on which and the circumstances in which the said powers could be exercised. So it is purely their discretion. But the said power being a constitutional power conferred upon the government by the Constitution is amenable to judicial review on certain limited grounds. Again, those limited grounds are your arbitrariness, unreasonableness, and then malafide. This is, the case of Jasbir Singh, who was involved in the conspiracy to assassinate Mrs. Indira Gandhi. And he was hanged also. Can be examined on the grounds of that in the exercise of this power, no consideration nor occasion can be wholly irrelevant, irrational. This is a change in stand. That the occasion should also be taken into consideration. It is not wholly irrelevant. Besides, the court would be justified in interfering with an order passed by governor if the governor is found to have exercised the power himself without being advised by the government, or if the governor transgresses the jurisdiction, or it is established that the governor has passed the order without application of mind. What is this application of mind? Yesterday, we have seen a similar colorable exercise of power. What cannot be done directly should not be done indirectly. That is colorable exercise of power. Application of mind is that when any facts or material is placed before the authority must go through it and apply his own wisdom, not act mechanically.